Imagine a crime so heinous, so shocking, that it shakes the very foundation of society. This is the chilling premise of the doctrine of rarest of rare cases. This principle is applied in circumstances where crimes are not just brutal and cold-blooded, but so grave that they shock the community as a whole. In these instances, the judicial system can inflict the most severe punishment, the death penalty. An intriguing illustration of this doctrine is found in the case of Mukesh versus State, NCT of Delhi. This case fell squarely within the category of rarest of rare cases, warranting the imposition of the death sentence. The circumstances of the crime were so severe that the scales of justice tipped in favor of the prosecution and against the accused. Now, how do we determine if a case qualifies as rarest of rare? The Supreme Court in Machi Singh v. State of Punjab formulated two probing questions. First, is there something uncommon about the crime that renders a life sentence inadequate, calling instead for a death sentence? Second, are the circumstances of the crime such that there is no alternative but to impose the death sentence, even after giving maximum weightage to any mitigating circumstances that may favor the offender? However, the doctrine has its critics. Some argue that it is too subjective, as it depends largely on the facts, circumstances, and brutality of the crime. Others argue from a humanistic perspective, suggesting that the doctrine violates the principle of reverence for life. To this end, the Supreme Court, in a landmark 2019 case, dismissed an appeal to impose the death sentence, instead awarding a life sentence without the possibility of commutation. The court argued that the brutality of an offense alone is not sufficient to qualify a case as rarest of rare. Additional factors such as mitigating and aggravating circumstances, the intensity of bitterness that had prevailed, and the escalation of simmering thoughts into a thirst for revenge or retaliation must also be considered. In summary, the doctrine of rarest of rare cases is a powerful tool in the hands of the judiciary. It is used in the most extreme cases, where the crime is so grave and shocking that it calls for the harshest punishment. However, it is a complex and nuanced doctrine, requiring a careful balance of numerous factors. This delicate balance ensures that it is applied judiciously and only in the most deserving cases. It underscores the gravity and seriousness with which society views such crimes, reinforcing the rule of law and the protective arm of the community. If you like this information, please share, like, and subscribe my channel.